element in that condominium. Well, what happens? The lien that you get, let's assume it's for a roof, because I'm going to give you a case where it actually was a roof. This was the Royal Ambassador condo case. What happened is the condominium defendants say, hey, you have to drag in every single unit owner and sue every single unit owner in the entire building. Well, the appellate court disagreed. They said no. The condominium association operates on behalf of, they've been elected by the condominium unit owners. They operate on behalf of the unit owners. You only have to sue the condominium association as the representative class of the entire condominium. But what does your lien extend to? Your lien only extends to, and here are the terms, and this is how you get away with only filing one lien instead of 100 liens against every single unit. The terms are, in your lien, against all units in accordance with their respective percentage share of the common expense of the condominium. In other words, and this language would be fine too, because this language came out of another case. The lien claimed on each unit is limited to that unit's proportionate share of common expenses. So let's assume that I don't pay there's a lien on my building. I own the penthouse, which is half of the floor in Hollywood. I own half the floor. I now want to sell it to somebody. I can't sell it because I got Southeast lien on it. What do? I look at my proportionate share of my common expenses in the building, whatever that percentage is. Southeast lien's $100,000. I say, Southeast, here's your check for my proportionate share. Give me a partial release of lien for my condominium unit, and that's how that gets out. Now, Southeast still has a lien on the rest of the entire building, but I'm released. Okay? Publicly owned projects, just want you to be aware, those are projects that are bonded. For instance, let's assume that you go ahead and you're doing work for the federal government. Don't ask me about Indian reservations, I'm not sure, that's a whole other area. But let's assume that you're doing work for the federal government and you started doing work and improving some federal project, and they don't pay you. You're not going to be able to foreclose on that property, get the property, and come over there and say, hey, guess what, this is now the new sovereign of me, and put a flag in the property. Ain't going to happen. There are bonds on those projects, so you go after the bond. The bond is like an insurance company that stands out there and says, in the event of non-payment, we'll pay, or the event that a contractor doesn't perform, we'll finish performing for you. There are different types of bonds. There are performance bonds and there's payment bonds. But today we're really talking about liens for the most part. And the last part is unreimbursed project funds. This is not really real estate. What I'm saying is that let's assume that there's a lender out there who isn't paying. I may want to put what's called an equitable lien against those funds, saying, hey, look, those funds need to be directed to me instead of going to somebody else. So it's not technically real estate. I'm just saying sometimes there's another avenue to go out there. And this isn't going to be anything that you can do. This would be something that a lawyer would have to do to go after some construction funds. Next page, we're on number 4. When an owner has no interest in the real estate, you can remove the items. Well, let's go back. Who has no interest in real estate? Tenants, for the most part. I'm going to talk to you about two things. Number one, 713.11 says if the contracting party has no interest in the real estate, then you can lien the improvement. And the way it's interpreted is to the extent removal is practical. The court may order the improvement sold and the land restored to substantially the same condition. And I've given you a case here. In this case, this Dargell Construction Company case, and this was all the way back in 1965. There aren't many cases on this, maybe a handful, where the liener was actually allowed to remove sewage treatment tanks, even though endangered the lives of many. The court said, I don't care, you didn't pay for it. Too bad. Can you take it out? Sure, can take it out. That's it. Well, this is used as leverage. So let's assume the tenant doesn't have the ability to pay, like in my case with the electrical contractor. I said, can we rip out that cable? He says, sure. Well, it's used as leverage. Believe me, somebody's going to want to pay because otherwise you're about to render that property. useless. I'll give you another example of where I'm using it in different forms, and that is a lot of cases I'm confronting. I'm finding that the banks, the lenders, are taking over the projects because the general contractor is going into default, the developer is going into default. There's millions of dollars out there that remain unpaid underneath notes, and the little guys are getting foreclosed out. So what happens? One of the actions that I'm bringing, or threatening to bring, and I haven't seen this played all the way out, is an action for injunctive relief and for similar type of relief as specified in here. For instance, right now I'm representing a painting contractor. The painting contractor, this is going to be a little bit more difficult, did wall treatments and painting of the entire buildings. I'm requesting to be able to sandblast off the paint and be able to peel off the wallpaper that we put on. Believe me, the people who are in there aren't going to want to see that happen. And the bank that now owns this property, they're laughing now, but they're going to be crying later. We'll see. Labor, materials, or services which are lienable. We are going to come back to this definition 100 times. I want you to be aware, you can't lien for everything under the sun. Only certain things are lienable. I see liens all the time, I would say almost 50%, that put in everything but the kitchen sink. I mean, it's great if you contracted for a kitchen sink, but otherwise, you can't lien for everything. And here's really the biggest definition, and this is my go-to definition. In order to be lienable, the item has to be actually incorporated into the project for its permanent benefit. So I'm going to give you an example. I was representing an owner versus a flood restoration company. The flood restoration company came in with a bunch of blowers and dried up the property. They didn't do anything else. All they did was dry up the property. They then gave her a bill for $10,000 after 4 days of using her electricity and running their blowers. It seemed a little bit of exorbitant, and based on their practices, it was an unfair and trade deceptive practice claim